Okay, let's unpack this. Marriage is a fundamental legal status, right? But what happens when that status changes, when a relationship actually ends?
Hmm.
How does the law navigate something so deeply personal? And, how has that whole approach evolved over time?
It's quite a story.
Yeah, it seems like a story of history, frustration, and some pretty dramatic recent shifts, especially in the UK.
Indeed, it's a legal area that perhaps more than any other really intertwines these abstract legal concepts with the very real, often quite painful experiences of individuals and families.
Uh-huh.
Understanding its history is just so key to appreciating where we are today.
Absolutely.
Yeah.
And that's precisely our mission today on the Deep Dive. We're taking a stack of information, our source material, and diving deep into the complex history and, well, the radical recent reform of UK divorce and civil partnership dissolution law.
Mhm.
We're going to trace its path, try to understand the foundational concepts, look at the pivotal cases, and really grasp how profoundly things have changed. This deep dive is built entirely on the source material provided, designed to give you a clear, comprehensive, and, well, hopefully, truly insightful understanding.
And we really should acknowledge and thank the University of London for making these valuable documents available.
Oh, definitely. Thank you for the sources.
Yes. And just to be clear, this deep dive is intended for educational purposes only, drawing solely from that material provided, and is brought to you by Sinorbit Academy, Sri Lanka.
Great. So whether you're studying this specific area, maybe navigating these issues in your personal life, or perhaps just generally curious about how the law handles the ending of relationships, we're here to guide you through the essential information contained in these documents. Let's get started.
Right. So to understand the scale of the changes, we really need to journey back in time, like long before a court could grant you a divorce as we might know it today. We're talking about the era before the Matrimonial Causes Act of 1857.
Before 1857. Wow. So what options did people even have back then if their marriage was genuinely broken?
Well, before that crucial act, there was no judicial decree of divorce that could dissolve a marriage and allow remarriage. It just didn't exist in that form.
Huh.
The closest thing available came from the ecclesiastical courts, the church courts.
Right.
And it was something called divorce mensa et thoro.
Divorce mensa et thoro.
Okay, bit of Latin there. What did that actually mean in practical terms?
It literally means from table in bed.
Nah.
It wasn't a divorce in the modern sense at all. It was essentially judicial separation.
So separation, not divorce.
Exactly. The couple was permitted to live apart. Their legal obligation to cohabit was ended by the court, but the fundamental legal bond of marriage, that remained completely intact.
Right.
So neither party was free to remarry. So you could legally live separate lives, but you were still, in the eyes of the law, married. What if you wanted to dissolve the marriage bond completely, to actually be free to remarry someone else?
Well, the only route available was through obtaining a private act of parliament.
A private act of parliament?
Yeah, this involved petitioning Parliament directly, asking them to pass a unique law just for you, specific to your individual circumstances, dissolving your marriage.
A custom-made law just for one couple. That sounds incredibly difficult. And probably very exclusive.
Oh, it absolutely was. The sources mentioned the first such act was obtained by the Duke of Norfolk way back in 1700.
So,
And the numbers really highlight just how rare this was. Between 1700 and 1856, that's over 150 years, only 317 private acts of parliament were ever obtained to dissolve a marriage.
only 317 in a century and a half. That really puts the difficulty and I imagine the cost into perspective.
It does. These acts were prohibitively expensive, often accompanied by unwanted, public scrutiny and gossip. And importantly, the sources highlight a really significant inequality.
Inequality how?
Very few wives were ever successful in obtaining these private acts compared to husbands. The system was just heavily skewed against women.
So that was the landscape before 1857. Separation via church courts maybe, or this vanishingly rare, super expensive, and unequal private act to truly end the marriage. So what pivotal change did the Matrimonial Causes Act 1857 actually bring?
The 1857 Act was, well, pretty revolutionary for its time. It established the Court for Divorce and Matrimonial Causes that was specifically given the power to grant judicial decrees of divorce.
Oh.
So for the first time, ordinary people, or at least those who could afford the court process, could seek a legal dissolution of their marriage through a civil court, which allowed them to remarry.
A civil judicial process for divorce. That's a huge step forward. But the sources are clear that from its inception, this new system was based on matrimonial fault. What does that core principle mean for getting a divorce under the 1857 Act?
It meant you had to prove your spouse had committed a specific wrongdoing, a recognized matrimonial offense. You had to point the finger and prove it.
Okay.
And even with this new judicial process, the inequality we saw from the Private Act era didn't just disappear overnight.
How was the inequality still present in the 1857 Act then?
Well, the law treated men and women differently regarding the grounds for divorce. It wasn't equal.
Right.
A husband could get a divorce solely on the ground of his wife's adultery. Simple as that, relatively speaking.
Yeah.
However, a wife could not get a divorce based only on her husband's adultery. That wasn't enough on its own.
Really?
Yes. She had to prove his adultery plus some other form of misconduct, like cruelty or desertion. So a higher bar for women.
Still unequal footing for women seeking a divorce, even with this new court system. How did this fault-based system and the specific grounds for divorce evolve as we moved into the first half of the 20th century?
There were gradual steps towards reform and formal equality. The Matrimonial Causes Act, 1923, that specifically addressed the inequality regarding adultery. It allowed wives to petition for divorce solely on the ground of their husband's adultery, finally putting men and women on an equal footing for that particular fault.
Okay, so 1923 brought equality on the adultery ground. What other grounds were added around that time?
The Matrimonial Causes Act, 1937, further expanded the grounds. So in addition to adultery, you could now petition based on cruelty, desertion, but it had to be for a period exceeding 3 years and quite significantly incurable insanity.
Incurable insanity as a ground for divorce. That sounds different from fault.
Yes. And the sources really point to this as a crucial historical development. Although the system was still overwhelmingly fault-based, incurable insanity was the first example of no-fault divorce introduced into English law.
The first example of no fault.
Yeah.
Interesting.
Yeah, it allowed for a divorce based on a condition, a state of being, not a matrimonial offense committed by the spouse. It was an early hint, maybe, of the idea that a marriage could end legally just because it had simply broken down in reality, regardless of who was technically to blame.
Fascinating that the seed of no fault was planted way back in 1937, even while the whole system remained so rooted in proving fault.
It really highlights that early recognition, I think, that focusing solely on fault didn't always align with the lived realities of marriage breakdown.
Okay, so we had a judicial divorce from 1857, expanded grounds, a move towards formal equality in the early 20th century, and this little no-fault toehold with incurable insanity. But the sources reveal that after World War II, there was this growing dissatisfaction with the whole matrimonial fault doctrine. What were the main problems people were identifying with this system?
The criticisms were significant, yeah, and definitely mounting. A primary concern was the feeling that requiring proof of a specific matrimonial offense, well, it often wasn't addressing the actual cause of the marriage breakdown.
Right.
Instead, committing adultery or behaving cruelly was frequently seen as a symptom that the marriage had already failed rather than the underlying reason it ended. The law was basically forcing people to assign blame, often quite artificially, even when the relationship had just sort of withered away.
So the law was making people perform this kind of legal ritual of accusation, which might not have reflected the deeper reality of why things fell apart.
Precisely. And this adversarial process, requiring proof of fault in court, it had a really detrimental effect. It was widely criticized because it often exacerbated the bitterness of the breakdown.
Exacerbated the bitterness. Yeah, I can see that.
It turned what was already a painful personal separation into this kind of public legal battle, forcing spouses to rake over difficult memories and make harsh allegations against each other in court documents.
Which sounds completely counterproductive if you hope for any kind of civil relationship afterwards, especially if there are children involved.
Absolutely. The sources strongly indicate that this process didn't help save marriages, and it certainly made the experience much more distressing for everyone involved, including any children. These were powerful criticisms really driving the call for reform.
Were there official inquiries or reports looking into these issues at the time?
Yes, there were. There was a royal commission that reported back in 1956, but its members were apparently quite divided on the best path forward for divorce law.
Yeah.
A more influential report, though, came in 1967 from a group appointed by the Archbishop of Canterbury, interestingly, titled Putting Asunder.
Putting Asunder.
Yeah.
Catchy title. What did that report recommend regarding the actual ground for divorce?
Well, this report was highly critical of the fault system. It famously described the whole matrimonial offense concept as, and this is, quote, quite simply, inept.
Inept. Strong word.
Yeah. Its central recommendation was that the sole ground for divorce should simply be the breakdown of marriage, completely removing the need to prove a specific fault.
Just breakdown. Pure and simple.
Mm.
How did they envision proving that in court?
Well, they proposed a more inquisitorial process.
Inquisitorial.
Yeah, where the court itself would actively investigate the marriage to determine if it had truly broken down irretrievably, rather than the existing adversarial system where one party had to prove the other's fault.
So the court would essentially become a kind of fact finder for the state of the marriage itself. That sounds like it could be a potentially lengthy and honestly quite intrusive process.
It does, yeah, and that was definitely a concern raised in response. The Law Commission followed up with their own report called The Field of Choice. Now, while they agreed that breakdown of marriage should be the sole ground, they felt the putting asunder proposal for this big inquisitorial inquiry wasn't really justiciable enough.
Justiciable.
Meaning it would be difficult for judges to apply consistently and fairly across different cases. They also worried about the cost and time involved in doing such an inquiry in every case, and the risk that this deep investigation might actually reopen wounds and increase bitterness, which would completely contradict the aims of reform.
Right, potentially making things worse, not better.
Mm.
So they supported the concept of breakdown, but disagreed on the method of proof. What did the Law Commission identify as the fundamental objectives of a good divorce law at this time? This seems important.
It is a crucial point, yeah, because these objectives really guided the subsequent reform efforts for decades. The Law Commission stated that a good divorce law should aim, first, to buttress rather than to undermine the stability of marriage.
Okay, support marriage where possible.
Right. And second, when a marriage has irretrievably broken down, to enable the empty legal shell to be destroyed with the maximum fairness and the minimum bitterness, distress, and humiliation.
Maximum fairness, minimum bitterness, distress, and humiliation. That phrase really captures the ideal outcome, doesn't it? It's about processing the legal ending in a way that minimizes the negative fallout for everyone involved.
It absolutely became a touchstone for reformers, that phrase. However, translating that ideal into actual legislation while navigating the practicalities of the legal system and, competing views led to what the sources call a compromise.
The compromise legislation. Okay, so this brings us to the Divorce Reform Act, 1969, which was later consolidated into the Matrimonial Causes Act, 1973.
Exactly. The 1969 Act was the result of balancing this desire for a breakdown-based system with the need for a clear, workable legal test. The sole ground for divorce did officially become irretrievable breakdown of marriage, reflecting that putting asunder recommendation. So on the face of it, that sounds like pure no fault.
It does, but there was a catch, wasn't there? A mechanism for proving this breakdown.
Yes, there was. You couldn't just state that the marriage had broken down irretrievably and get a divorce. You had to prove it by satisfying the court of one or more of 5 specific facts.
5 facts.
5 facts. And this is where the link back to the old fault system remained pretty strong, as 3 of these 5 facts were essentially derived directly from the old fault grounds.
So irretrievable breakdown was the overarching ground, the headline reason, but the specific evidence required was proving one of these 5 facts. And this Matrimonial Causes Act, 1973, this framework, it remained the law for a very long time, right?
It did, yeah. The MCA 1973, which incorporated those 1969 reforms, remained the governing legislation for divorce in England and Wales right up until April 2022, for nearly 50 years.
Wow.
Under this law, the ground was irretrievable breakdown, proved by establishing one of these 5 facts. Remember that. Irretrievable breakdown proved by one of 5 facts.
Okay, got it. Before we detail those 5 facts, though, the sources mention a bar on early divorce in this old system. What was that restriction about?
Right. There was a legal barrier to seeking a divorce very soon after getting married. Initially, under the 1937 Act, there was actually a 3-year prohibition from the date of the marriage.
3 years.
Yeah. You couldn't petition for divorce during those first 3 years unless you could prove exceptional hardship or, get this, exceptional depravity.
Exceptional hardship or exceptional depravity. Wow. 3 years feels like a long time if a marriage has genuinely broken down very early on.
It is, and the Law Commission reviewed this back in 1982. They found that the 3-year bar didn't really effectively save marriages or deter inappropriate divorces. It mainly just delayed things.
Right.
And problematically, it incentivized people to kind of exaggerate difficulties or make highly distressing allegations to try and qualify for those exceptional categories.
Forcing people to make things sound much worse than they perhaps were just to escape that waiting period.
Exactly. So while they still felt a short period should probably exist to discourage really hasty divorce, the law was changed in 1984. This introduced a provision into the MCA 1973, reducing the bar significantly to just 1 year from the date of the marriage.
1-year bar. Okay, that
Mm.
sounds more reasonable. Is that restriction still in place under the new law we have now?
Yes, that's an important point in continuity. The sources clearly note that this 1 year period remains under the current Divorce, Dissolution, and Separation Act 2020. You still cannot legally start divorce proceedings within the first year of marriage.
Okay, good to remember that the 1-year bar remains. Now let's really dig into that central mechanism of the old MCA 1973 law, proving the ground of irretrievable breakdown by establishing one of the 5 facts. The sources quote the main section of the Act, Section 1.1, which stated, "A petition for divorce may be presented on the ground that the marriage has broken down irretrievably."
Yes, that was the opening statement in the relevant part of the Act, Section 1. But, as the source highlights, this wording was often quite misleading in practice.
Misleading. How so?
For 2 key reasons, really.
Okay.
Reason 1. As we've just discussed, you couldn't actually get a divorce simply by showing a marriage had broken down. You absolutely had to prove one of the 5 specific facts as evidence of that breakdown.
Right.
And remember, 3 of those facts were based on the old fault concept: adultery, behavior, which effectively replaced cruelty, and desertion. So it wasn't really just about breakdown.
So the real requirement wasn't just breakdown, but breakdown plus proof of one of those 5 facts. The facts were the gatekeepers.
Exactly. The facts became the gateway. And reason 2, why the irretrievable breakdown ground was misleading, relates to how the courts actually handled it in practice. Another section of the Act, Section 1.3, directed the court to inquire into the facts alleged by the petitioner and any facts alleged by the respondent.
Okay, suggesting some kind of investigation.
Yeah, it suggests a thorough investigation into whether the marriage was truly broken. But how did that play out in reality?
How did it?
In practice, once a petitioner successfully proved one of the 5 facts, a divorce decree was almost automatically granted, just followed almost inevitably.
Automatically, why?
This was largely due to a procedural innovation that came in called the special procedure.
The special procedure, what did that involve?
The special procedure basically allowed courts to grant divorce decrees in undefended cases, where the respondent didn't contest the divorce based simply on the paperwork submitted, there was no need for a court hearing. So if the petitioner's sworn statement seemed to prove one of the 5 facts on paper, the court generally didn't conduct any deeper inquiry into the actual state of the marriage breakdown itself.
So if you could present a case on paper that ticked the box of one of the 5 facts, and your spouse didn't formally defend it, the divorce was effectively just rubber stamped.
Yes, that became the practical reality for the vast, vast majority of divorces under the MCA 1973. Furthermore, another part of the Act, Section 1.4, placed the burden on the respondent, the person receiving the petition, to prove that the marriage had not broken down irretrievably.
That sounds hard to prove.
Exceedingly difficult to do once the petitioner had successfully established one of the 5 facts. It really made the idea of the court genuinely inquiring into irretrievable breakdown less central to the process than simply establishing one of the required 5 facts.
Okay, so let me recap that because it seems crucial for understanding the old system. Under the old MCA 1973, the formal ground was irretrievable breakdown, but the practical requirement was proving one of the 5 facts. This was often done via the special procedure on paper, which usually bypassed any deep inquiry into the actual breakdown itself. And critically, without proving one of those 5 facts, there could be no divorce, no matter how clearly the marriage had ended in reality.
That is precisely the key takeaway about the old system, yes. And that's where so much of the criticism eventually stemmed from. It trapped people in marriages if they couldn't quite fit their situation neatly into one of those 5 legal boxes.
Right. Let's explore each of those 5 facts in more detail then. They were the absolute bedrock of divorce law for decades.
Indeed. And remember, for the exam, you need to know these 5 facts. Proving just one of them was sufficient.
Okay. Fact number 1, adultery, coupled with intolerability, Section 1.2a.
Correct. This required proving 2 things. First, that the respondent, the person being divorced, had committed adultery. The legal definition of adultery in this context was quite specific: voluntary sexual intercourse between a married person and someone of the opposite sex who was not their spouse.
Opposite sex home.
Yes, that was the legal definition. And the sources specify that penetration was sufficient.
Got it. And who could use this fact? Could you rely on your own adultery?
No. Only the spouse who had been cheated on could petition for divorce based on the other spouse's adultery. You couldn't use your own adultery as the basis for your petition.
Okay. And the second part was that the petitioner found it intolerable to live with the respondent.
Yeah.
Section 1.6 dealt with this.
Yes. The petitioner had to state they found it genuinely intolerable to continue living with their spouse. Now, a very significant point of judicial interpretation on this fact came from the case of Cleary v. Cleary. That's C-L-E-A-R-Y, Cleary v. Cleary, 1974.
Cleary v. Cleary, 1974.
Yeah.
Okay, what did that case establish about the link or lack of link between the adultery and the intolerability?
Well, the Court of Appeal in Cleary v. Cleary made a key ruling. They established that the fact was proven if the respondent had committed adultery and the petitioner genuinely found it intolerable to live with them. Crucially, there was no requirement to prove that the adultery caused the intolerability.
No causal link needed?
No. The intolerability didn't have to be by reason of the adultery. The two elements just had to exist. Adultery happened, and the petitioner finds it intolerable to live with the respondent.
That's a really crucial distinction. So you could find out about the adultery, and for entirely separate reasons, you find it intolerable to live with them. And that would be sufficient under this fact, according to Cleary v. Cleary.
Yes, that was the interpretation following Cleary v. Cleary. It really highlights how the law sometimes created almost a technical route to divorce based on the fact existing, even if the ultimate breakdown wasn't solely driven by that specific event. Remember Cleary v. Cleary for that point.
Right. Fact 2, behavior, section 1.2. The sources say this was the most frequently used fact.
By far. It was the basis for the vast majority of divorce petitions under the old law. This fact required proving two distinct elements. First, you had to show that the respondent had behaved in a certain way. Pretty straightforward.
Okay.
Second, and this is the crucial part, that because of that behavior, the petitioner cannot reasonably be expected to live with them.
Cannot reasonably be expected to live with them. That phrase sounds like it requires quite a judgment call from the court.
It does. And the sources make a vital clarification here. The test is not whether the respondent's behavior itself was unreasonable.
Ah, okay.
The test is whether it is unreasonable to expect the petitioner to continue living with them, given that behavior. The behavior could be relatively minor incidents over time, but if their cumulative effect made ongoing cohabitation unreasonable for that specific petitioner, the fact could potentially be established.
So it's really about the impact of the behavior on the petitioner and whether it's reasonable to expect them to endure it, rather than judging the behavior itself in isolation.
Yeah.
Cases like Bannister v. Bannister 1980 dealt with the court's role here, you mentioned.
Yes, and this is the fact, of course, that featured so prominently in the very important case of Owens v. Owens. We absolutely need to remember Owens v. Owens when discussing behavior. We'll come back to it as it was such a catalyst for the final reform.
Okay, so behavior was complex. Fact 3, desertion, section 1.2c.
Right. This fact required proving that the respondent had deserted the petitioner for a continuous period of 2 years immediately before the divorce petition was filed. Desertion for 2 years.
Desertion for 2 years. The sources mentioned this was the least common fact used. Why was that?
It was, relatively insignificant in terms of numbers. As the sources explain, if someone wanted a quick divorce based on fault, adultery or behavior were typically faster routes, assuming you could prove them. If they wanted a divorce based on separation without alleging fault, the 2-year separation with consent, which is fact 4, was generally preferred because it didn't involve proving the specific legal elements of desertion, like the intention to desert, which could sometimes be tricky. So desertion was usually only relied on if parties had been separate for 2 years, but the respondent stubbornly wouldn't consent to fact 4, or maybe to avoid the potential hardship defense under the 5-year separation fact, which is fact 5.
Okay, that leads us neatly to fact 4 then. Living apart for 2 years plus consent. Section 1.2.
Yes, this was a very significant addition in the 1969 Act. The sources explicitly identify this as the first no-fault divorce fact introduced into English law via that act.
The first concrete step towards no-fault divorce in the UK system, embedded within the old structure. What did it require?
It required proving 2 things. That the couple had been living apart for a continuous period of 2 years immediately before the petition, and that the respondent consented to the divorce. 2 years separation with consent.
And note the wording. It used consent. A positive agreement was needed, not just a lack of objection, right?
Exactly. Positive consent was required from the respondent.
And what did living apart mean legally? Did you have to be in different houses?
The sources explain that living apart required both a physical element and a mental element. Remember both. Physical and mental
And
elements.
physical and co, okay.
The physical element generally meant not sharing a home in the sense of living together as a couple. The mental element meant that at least one of them regarded the marriage as over and intended to live separate lives.
Right.
The statutory definition in Section 26 of the MCA 1973 clarified this. It said, "A husband and wife shall be treated as living apart unless they are living with each other in the same household." Let's repeat that. Living apart unless they are living with each other in the same household.
So it was possible, legally speaking, to be living apart, even if you were still physically under the same roof, as long as you weren't sharing a household in the traditional sense, maybe separate rooms, separate lives, separate finances, that kind of thing.
Yes, exactly. That was the judicial interpretation. It focused on the nature of the cohabitation, not just the shared physical building.
Okay. And finally, Fact 5, living apart for 5 years. Section 1(2)(e).
Similar to Fact 4, this required proving a continuous period of 5 years of physical and mental separation immediately before the petition. 5 years separation.
5-year separation. So what were the crucial differences between the two separation facts? Fact 4, 2 years with consent, and Fact 5, 5 years.
Two key differences to remember. First, consent. Fact 4 required the respondent's consent. Fact 5 did not require consent.
Right.
A petitioner could seek a divorce after 5 years of separation, even if their spouse strongly objected.
Okay, so the longer waiting period essentially allowed you to override the other person's objections.
Precisely. And the second difference was a potential bar to the decree, but only under Fact 5, the 5-year separation. There was a provision, Section 5 of the MCA, that allowed the court to refuse to grant the divorce if it was satisfied that dissolving the marriage would cause grave financial or other hardship to the respondent.
Grave financial or other hardship. That sounds like a potential safety net for the spouse who didn't want the divorce after such a long separation.
It was certainly intended that way, yeah. To protect the respondent, particularly perhaps a wife who might be significantly disadvantaged financially or otherwise by a divorce they didn't consent to after 5 years apart.
But did it work in practice?
Not often. The sources note that due to quite restrictive legal drafting and how judges interpreted the word grave, it had to be really serious hardship. This defense was rarely used successfully in practice. The bar to stopping a divorce on this ground was set very, very high.
So let's just quickly recap those 5 facts under the old MCA 1973. You needed just one. 1. Adultery plus the petitioner finding it intolerable to live with the respondent. Cleary said no causal link needed. 2. Behavior such that the petitioner cannot reasonably be expected to live with the respondent. Owens v. Owens is the key case here. 3. Desertion for 2 years. 4. Living apart for 2 years with the respondent's consent, the first no-fault fact. Or 5. Living apart for 5 years, no consent needed, but a rarely successful grave hardship defense existed.
That's a perfect summary. And the crucial point again, without proving just one of these specific 5 facts, even if the marriage was clearly over in reality, you simply could not get a divorce under the law that existed until 2022.
And that rigidity, that requirement to fit the marriage breakdown into one of those 5 boxes was a significant source of criticism and difficulty, wasn't it?
Absolutely. It led to further attempts at reform, though the sources describe a rather slow and failed path, particularly with the Family Law Act 1996.
Right. Before we get to the 1996 Act, the sources mention that even within the 1973 Act itself, there were some provisions aimed at reconciliation.
Yes, the Divorce Reform Act 1969 MCA 1973 did include measures intended to encourage reconciliation. For example, Section 6(1) required the solicitor filing the petition to also file a certificate, stating they had discussed the possibility of reconciliation with the petitioner and given them contact details for relevant support organization. And Section 6(2) allowed the court to adjourn the proceedings if it seemed there was a reasonable possibility of reconciliation.
Sounds like a good idea on paper, trying to save marriages. Did they work?
Good intentions, perhaps, but the sources note these provisions were largely ineffective and had little impact in reality. They were often criticized for coming too late in the process, when minds were already made up, or just being a tick-box exercise.
And there's a key distinction that wasn't being adequately addressed by these provisions, right? Something about reconciliation versus conciliation.
Yes, exactly. The 1974 Feiner Committee report on one-parent families highlighted this crucial difference. Reconciliation means the spouses actually getting back together and saving the marriage.
Right, fixing the relationship.
Whereas conciliation, on the other hand, is about helping parties manage the consequences of a breakdown that has already happened, assisting them to reach agreements on issues like children and finances with minimum conflict and bitterness. Remember that distinction. Reconciliation versus conciliation.
So reconciliation is trying to mend the relationship itself, while conciliation is trying to make the separation process as smooth and constructive as possible. The old laws focus on those often ineffective reconciliation provisions, sometimes missed the more pressing need for conciliation services.
Exactly. And the calls for deeper, more substantive reform continued throughout the 70s and 80s. The 1985 Booth Committee report, although its main focus was on procedure, reiterated that the fault element in divorce law exacerbated bitterness.
That key phrase again, exacerbated bitterness, it keeps coming up.
It does, demonstrating just how persistent the concerns about the old fault-based system were. This led the Law Commission to produce further reports, exploring alternatives more radically. In 1988, their discussion paper, Facing the Future, looked at how other countries handled divorce and actually favored a process over time model.
A process over time model.
Yeah.
What did that entail exactly?
Well, the basic idea was that instead of having to prove a fault or a specific separation period, one or both parties would simply file a notice stating their intention to divorce.
Okay.
This would then trigger a mandatory waiting period. After this period had elapsed, the divorce would be granted more or less automatically, without needing to prove one of the 5 facts, assuming arrangements for children and finances were sorted out.
That sounds much closer to a pure no-fault system based on a declaration and then just a defined waiting period.
It was a significant move in that direction, yeah. This model was developed further and led to a 1990 Law Commission report, which even included a draft bill. Subsequent proposals from the Lord Chancellor in the mid-1990s continued this theme of trying to minimize fault-based reasons for divorce.
And all of this intense planning and debate eventually culminated in the Family Law Act 1996.
It did. The FLA 1996 was a major piece of legislation that aimed to overhaul large parts of family law, including divorce. It received royal assent in 1996 after a very difficult and contentious passage through Parliament. However, and this is absolutely critical, Parts 2 and 3 of the Act, which contain the core reforms to divorce law, were never fully implemented.
Never implemented. It got royal assent, became an act of Parliament, but the key divorce parts just sat there.
That's right. The source notes they were later formally repealed entirely in 2014, a point confirmed by Lord Irvine at the time. It was, in essence, a failed reform attempt, at least regarding its core divorce provisions. It never happened.
Wow. So why is it still relevant to discuss then if it never actually came into effect?
Because, as the sources explain, it provides really valuable insight into what might have been. It shows the direction thinking was going in, and it highlights the huge political and practical challenges of enacting significant reform in this very sensitive area of law. Under this unimplemented act, irretrievable breakdown would have remained the sole ground for divorce.
Okay, sole ground, still irretrievable breakdown. And it had guiding principles, similar to those earlier Law Commission objectives we talked about.
Yes. Part 1 of the Act set out a number of principles. These included supporting marriage, attempting to save it if practicable, but also, when it had broken down, ending it with the minimum distress to the parties and any children affected. Also promoting good continuing relationships, avoiding undue costs, and reducing the risk of domestic violence.
Those sound like very positive, sensible goals. What was the detailed procedure proposed under the unimplemented divorce parts of the FLA 1996?
It was essentially that process over time model we mentioned. Either or both parties would start by making a statement of breakdown, just a statement. And the statement was intended to be taken as proof that the marriage had broken down. However, you couldn't even make the statement until 3 months after attending mandatory information meetings.
Mandatory information meetings.
Yeah.
So the state was actually requiring couples considering divorce to attend these meetings as a prerequisite.
Yes, this was a key and ultimately controversial feature. You had to attend, wait 3 months, then make the statement.
Okay. And what happened after the statement of breakdown was made?
Following the statement, a mandatory period of reflection and consideration would begin. This period was set at 9 months as a standard, but it extended to 15 months if there were children under the age of 16 involved.
9 or 15 months. That's a long time.
A very significant period, yeah. And this reflection period officially started 14 days after the court received the statement of breakdown. During this time, parties were expected to reflect on whether the marriage could be saved and consider the consequences and arrangements for the future.
So mandatory meetings first, then a statement, then this very long mandatory reflection period, 9 or 15 months before you could actually finalize the divorce. This was a significant state intervention aimed at potentially saving marriages, or at least ensuring people were fully aware of the consequences before proceeding.
It was certainly intended to encourage reflection, explore reconciliation if possible, and facilitate arrangements for the future, yes. After this mandated reflection period had passed, the court could then grant the final divorce order, which they were calling a divorce order, not a decree.
So why did this detailed, principle-driven process ultimately fail? Why was it never brought into force and eventually repealed?
The sources pinpoint the unsuccessful piloting of the information meetings as the primary reason for the failure of Part 2. Section 8, which mandated these meetings, was absolutely essential to the whole scheme.
Unsuccessful piloting of the information meetings. What went wrong?
The research conducted during the piloting phase was crucial, and frankly, it just didn't support the effectiveness of the intended process.
What did the research actually reveal about these mandatory meetings?
The findings were quite problematic. While attendees often found the information provided useful, the meetings were found to be not effective in actually saving marriages.
Right.
Often, people attended far too late in the process when the decision to divorce had already been effectively made. The research even suggested they might, in some cases, push people who were uncertain towards divorce rather than away from it.
Oh, interesting. Unintended consequence.
Yeah. They were also found to be too inflexible, kind of a one-size-fits-all approach, not tailored to the personal needs of individuals. People often preferred seeking advice directly from their own solicitors rather than engaging with the mediation pathways offered via the meetings.
Okay.
And perhaps the fundamental issue was that the success of things like marriage counseling and mediation depends very heavily on the willing involvement of both parties. But typically, only the petitioner was legally required or motivated to attend these initial information meetings.
So the central mechanism, intended to promote reconciliation and reflection, just didn't work as planned in the real world and had unforeseen negative issues.
Exactly. That, coupled with widespread concerns that the complex procedures of Part 2 would likely cause significant delay and uncertainty in resolving crucial matters, like finances and arrangements for children, which ran completely counter to the guiding principle of minimum distress, led the government to conclude that Part 2 was simply not the best way forward.
And Lord Irvine, who was the Lord Chancellor at the time, he publicly confirmed this failure.
Yes, the sources quote him stating quite clearly that the comprehensive research showed Part 2 was not achieving its stated aims effectively. He announced the intention was therefore to repeal it when a suitable legislative opportunity arose.
Which, as you said, eventually happened in 2014.
Correct.
So, after the high hopes and ultimate collapse of the FLA 1996 reforms, the law reverted to, or rather, just remained as, the old 1969 Act MCA 1973 system, the one based on the 5 facts, which, as the sources rather starkly put it, continued to reflect the preoccupations of the 1960s, stuck in that position.
Precisely. The law was widely seen as problematic and outdated, but a major ambitious attempt at reform had completely collapsed. It was a difficult period.
What finally broke that deadlock then? What was the catalyst that pushed the UK towards the successful reform we have today?
Well, the sources strongly highlight the case of Owens v. Owens. Remember that name, Owens v. Owens. Heard in the Court of Appeal in 2017 and affirmed by the Supreme Court in 2018.
Right.
That case and the significant public attention it garnered was a major driving force for renewed demands for reform.
Owens v. Owens. This is the case that really demonstrated the harsh realities of the old law in action, particularly that behavior fact, didn't it?
It absolutely did. Mrs. Owens sought a divorce based on her husband's behavior under Fact 2 of the old MCA 1973. Now, both the initial court and ultimately the Supreme Court, while acknowledging that the marriage had clearly broken down in reality, everyone accepted that found that Mr. Owens' behavior, as presented in court, didn't meet the strict legal threshold required by the old law. Meaning it wasn't considered so bad that she couldn't reasonably be expected to live with him under that specific legal test, even though she subjectively felt she couldn't.
So even though the marriage was admittedly over, completely finished, she couldn't legally prove one of the 5 facts to the court's satisfaction under the strict interpretation of the old legislation. She was, in effect, legally trapped in a marriage she desperately wanted to end.
Exactly. The Owens v. Owens case starkly illustrated the fundamental problem with the old law. A marriage could be dead, in fact, but if you couldn't successfully navigate the legal hoops and prove one of the prescribed 5 facts, you couldn't get a divorce. This case resonated very widely with the public and significantly increased the pressure for legislative change, specifically for a proper no-fault system. Remember, Owens v. Owens as illustrating the failure of the old law.
That public and legal pressure, presumably combined with further reports, the sources mentioned those Nuffield Foundation reports like Finding Fault, No contest, and taking notice, which detailed the problems and explored alternatives, finally led to successful reform.
Yes, it all culminated in the Divorce, Dissolution, and Separation Act 2020, or DDSA 2020 for short.
The DDSA 2020, okay. When did this act actually come into force? Because there was a delay, wasn't there?
That's right. It received royal assent back in June 2020, but the crucial provisions, including the core no-fault changes, didn't actually come into force until April 2022.
April 2022.
Yeah, this delay allowed the courts and legal professionals, time to prepare for the quite significant changes to the system.
So the law we are operating under right now has only been in effect for just over 2 years. What is the core radical change it introduced?
Simply put, it introduced genuine no-fault divorce into English law, finally.
Okay. How does it achieve that no-fault system? What's the mechanism?
It significantly amends the Matrimonial Causes Act, 1973. The amended Section 1.1 on the ground for divorce now states that either party, or crucially, both parties jointly, can apply for a divorce order on the ground the marriage has broken down irretrievably.
So the ground itself is still irretrievable breakdown. That hasn't changed.
Correct. The formal ground remains the same, but the way you establish or prove it is fundamentally different. The amended law, Section 1.2, now states the application for divorce must simply be accompanied by a statement from the applicant or from both applicants in a joint application confirming that the marriage has broken down irretrievably.
Just a statement from the person or people applying. No details needed.
Just the statement. And this is the crucial radical change in Section 1.3. The amended law mandates that the court must take that statement as conclusive evidence that the marriage has broken down irretrievably.
Conclusive evidence.
Yeah.
Let that sink in. The court must accept the applicant's statement as the final, undeniable proof of breakdown. No questions asked.
Exactly. The requirement to provide evidence by proving one of the specific 5 facts, adultery plus intolerability, behavior desertion, 2-year separation with consent, or 5-year separation is completely removed. Gone.
The 5 facts are removed.
Yes. It's replaced by the simple notification process where the court accepts the applicant's declaration of irretrievable breakdown as definitive and must make the order.
Wow. That is a dramatic shift from the old system where you had to somehow box yourself into one of those 5 specific scenarios, often leading to acrimony or delay. No more needing consent for 2-year separation if your spouse objects. No more having to dredge up painful details to prove fault. No more waiting 5 long years. You just declare it's broken, and the court accepts that.
That's the practical effect of the conclusive evidence provision, yes. It transitions the legal process from one of inquiry into why the marriage ended, based on those specific 5 facts, to one of simply facilitating the legal ending once a party declares the marriage has broken down irretrievably. The statement is conclusive evidence.
Okay, so what does the new divorce process and the timeline look like under the DDSA 2020? How does it work step by step?
It's designed to be much more streamlined and less adversarial. You make the application, which can be a sole application by one spouse or, significantly, a joint application by both spouses together. And that application must include that required statement of irretrievable breakdown.
Okay, application filed with the statement.
Yeah.
And then there's a waiting period involved. I remember something about that.
Yes. There is now a mandatory minimum 20-week period that starts from the date the court issues the application. This is specifically intended as a period for reflection, but also, crucially, to allow parties time to cooperate and make necessary arrangements for the future, regarding finances and children, for example.
A mandatory 20-week period, so roughly 5 months, leading to what?
After this minimum 20-week period has passed, and assuming the applicant or applicants still wants to proceed, the court can make a conditional divorce order. This used to be called the decree mise. Now it's the conditional divorce order.
Conditional divorce order after 20 weeks minimum. What happens after that? Is that the end?
Not quite. After the conditional order is made, there is a further minimum waiting period of 6 weeks.
Another 6 weeks?
Yes. Once that 6-week period has passed, the applicant, or one of the joint applicants, can apply to the court for the final divorce order. This used to be the decree absolute. Now it's the final divorce order.
Okay, so 20 weeks minimum, conditional order, then another 6 weeks minimum, final order. So the total minimum time from submitting the initial application to getting the final divorce order is around 26 weeks, so about 6 months, plus whatever time the court takes to initially process the application at the start.
Correct. This clearer timeline is now enshrined in the law, providing a more predictable, albeit still somewhat lengthy, process compared to some systems. And the sources highlight that this reform aligns the UK much more closely with many other jurisdictions around the world that have already moved to a similar no-fault notification system.
It definitely sounds much simpler and hopefully less confrontational than the old fault-based system, or that incredibly complex, unimplemented process from the FLA 1996.
But the sources mention there might be some potential remaining issues or tensions with this new law. What are those?
Yeah, the sources point to a potential tension identified by legal commentators like Professor Herring. The law still states that the ground for divorce is irretrievable breakdown. That's the legal basis. Yet the mechanism for proving this is simply the applicant's statement, which, as we've said, the court must take as conclusive evidence.
Right, the tension between the stated legal ground and the automatic method of proof. Exactly. It raises interesting questions about how this operates in practice. For instance, as highlighted in a sample scenario from the sources that we'll look at later, what happens if one spouse makes a statement of irretrievable breakdown when, factually, the couple are still living together in all ways, seemingly sharing a life? The law says the court must accept the statement as conclusive evidence of breakdown, regardless of that apparent living situation.
That's a fascinating point. So the law requires the ground to be breakdown, but the court's role isn't actually to investigate the reality of that breakdown anymore. It's simply mandated to accept the statement as true. It seems the new law is less about the state verifying the actual breakdown and much more about accepting the individual's declaration that it has occurred and then just facilitating the legal process efficiently.
It definitely represents quite a philosophical shift, moving away from state oversight of the reasons for breakdown towards state acceptance of the individual's subjective experience of the marriage's state, and facilitating the end with less fiction.
Okay, that covers divorce for married couples comprehensively. What about the ending of civil partnerships? How does that work now?
Right. For same-sex couples, civil partnerships can also be brought to a legal end, of course. This process isn't called divorce, though. The terminology is different. It's termed dissolution, and the final order is a dissolution order. Remember that. Dissolution and dissolution order.
Dissolution leading to a dissolution order. Got it.
Exactly. This was previously governed by specific parts of the Civil Partnership Act 2004, the CPA 2004. And just like divorce, the ground for seeking dissolution under the old law was irretrievable breakdown.
Irretrievable breakdown again. And before the DDSA 2020 changes, did civil partners also have to prove specific facts similar to married couples under the old law?
Yes, they did. Under the old CPA 2004, civil partners had to prove one of 4 specific facts as evidence of irretrievable breakdown. These were behavior, 2 years separation with consent, 5 years separation, and desertion for at least 2 years.
That sounds very similar to the divorce facts, just missing one. Which one was different?
Yes, a notable difference was that adultery was not one of the specific facts that could be used as evidence for the dissolution of a civil partnership.
Oh, okay.
The sources mention the reasoning given at the time the CPA 2004 was enacted was that adultery has a specific meaning within the context of heterosexual relationships, and it would not be possible nor desirable to read this across to same-sex civil partnerships. That was the official line.
So, historically, adultery was a fault ground for divorce, but specifically not a basis for civil partnership dissolution. How did the DDSA 2020 impact civil partnership dissolution? Did it bring them into line?
Yes, completely. Since coming into force in April 2022, the DDSA 2020 has harmonized the law for both marriages and civil partnerships in this respect. It removes the requirement for proving specific facts for the dissolution of a civil partnership as well.
Oh, so just like with divorce now, civil partners no longer have to prove behavior or specific separation periods or desertion.
Correct. The requirement to prove any of the old 4 facts is gone for dissolution too. The process for dissolution now mirrors the new divorce process very closely.
Okay.
There is still a 1-year bar before a civil partnership can be dissolved, just like the 1-year bar for divorce. That's in Section 41 of the CPA 2004. And the terminology for the stages is the same. There's a conditional dissolution order and a final dissolution order.
So the key takeaway here is that dissolution law under the DDSA 2020 is now largely aligned with divorce law. It removes the need to prove facts, just requires the statement of irretrievable breakdown, which is conclusive evidence, has the same 1-year bar and the 20-week and 6-week periods. The main historical difference about adultery not being a fact is now irrelevant to the process itself.
Exactly. The process is designed to be equitable and consistent for ending both marriages and civil partnerships under the new system.
Okay, let's briefly consider the perspective of human rights. Is there actually a human right to divorce? Could the old law, or even the new one, be challenged on human rights grounds?
The sources touch on this, yeah, specifically in relation to the European Convention on Human Rights, ECHR, which is incorporated into UK law by the Human Rights Act 1998. The ECHR does recognize a right to marry. That's clear from cases like Johnston v. Ireland and F v. Switzerland.
So, there's definitely a right to marry. Does that automatically imply a right to get divorced if the marriage breaks down?
Not according to the interpretations discussed in the sources, no. They note that the ECHR does not necessarily include a right to divorce, again referencing cases like Johnston v. Ireland.
Interesting.
While the convention prevents states from unduly restricting access to marriage, or, importantly, remarriage, as seen in F v. Switzerland, it appears to give states quite a bit of latitude, what they call a margin of appreciation, in regulating access to divorce itself.
So what's the implication of this for UK divorce law under the Human Rights Act?
Based on these precedents from the European Court of Human Rights, the sources conclude that the current UK law on divorce, and presumably the previous law too, is unlikely to be successfully challenged as a breach of the convention simply because it regulates the process or timing of divorce.
So while human rights principles are certainly part of the broader legal framework, the specific interpretation of the ECHR doesn't seem to mandate a particular model of divorce law or guarantee an easy, instant right to obtain one. States have some room to legislate here.
That appears to be the established position based on the case law discussed in the sources, yes.
We have covered a huge amount of ground today, a really significant journey through legal history. From the days of needing a private, bespoke act of parliament, to the introduction of the fault-based judicial system with its mandatory 5 facts and the practical reality of the special procedure, the ambitious but ultimately failed attempt at a process-based reform with the Family Law Act 1996 and its mandatory meetings and reflection periods, the crucial catalyst of cases like Owens v. Owens, which starkly highlighted the flaws in the old system, finally leading us to the radical shift to the no-fault system under the DDSA 2020.
It is quite remarkable when you trace it like that. And remembering the key elements. The statement of irretrievable breakdown now being taken as conclusive evidence, the complete removal of the 5 facts, and the new 20-week and 6-week minimum waiting periods. We've also seen how the law for dissolving civil partnerships via dissolution orders has followed a parallel path and is now largely aligned with the new divorce system.
Definitely. Key moments and terms to really lock in for studying are the Matrimonial Causes Acts, especially 1857 and 1973, the Divorce Reform Act 1969, the Failed Family Law Act 1996, the crucial Divorce, Dissolution, and Separation Act 2020, effective April 2022. Also concepts like divorce immensa et thorough, the 5 facts under the old law, remembering Cleary on adultery plus intolerability, and especially Owens v. Owens on behavior, the impact of the special procedure, the important distinction between reconciliation and conciliation, the unsuccessful piloting of information meetings is the key reason the FLA 1986 failed, and now the shift to a statement of irretrievable breakdown being conclusive evidence under the new law, along with the new 20-week and 6-week waiting periods, and don't forget the 1-year bar remains.
Absolutely. Understanding this historical context and these specific details, the acts, the cases, the concepts, is just vital for grasping why the law changed so dramatically and what the current legal framework for ending marriages and civil partnerships actually looks like in practice today. The move to no fault under the DDSA 2020 fundamentally changes the process from one requiring evidence of specific events or separation periods to one based primarily on a party's declaration, which the court is now bound to accept.
This new law certainly seems designed to reduce conflict compared to the old fault system, doesn't it? Aligning with that long-stated goal of minimum bitterness, distress, and humiliation.
That was absolutely a primary driver of the reform, yes. The new system arguably reflects a more modern view that the state's main role here is to formalize the end of a relationship relatively efficiently once a party declares it's broken, rather than to scrutinize the reasons for the breakdown or mandate potentially intrusive attempts at reconciliation, as the failed FLA 1996 tried, perhaps unwisely, to do.
This knowledge is incredibly valuable. Let's just spend a few minutes thinking about how you, the listener, might apply it. Perhaps if you're preparing for an exam on this specific topic.
Yeah, a good way to consolidate the learning. Consider the essay question posed in the sources. The road to reforming divorce law has been slow, but the result is a divorce law which suits the 21st century view of how involved the state should be. Discuss. How would you tackle that?
Right. Listener, think about how you would structure your answer using everything we've covered today. You definitely need to start by discussing the problems with the old 1973 law, wouldn't you? Lay out the criticisms.
Oh, absolutely. You'd need to detail those criticisms clearly. How the disconnect between the supposed ground of irretrievable breakdown and the necessity of proving one of the five facts made it confusing, potentially dishonest, and sometimes unjust. How it could distort bargaining power in financial negotiations, how the adversarial nature, especially with fault facts like behavior, provoked unnecessary hostility and bitterness. Remember, exacerbated bitterness, the negative impact this could have on children, and the simple fact that it didn't actually seem to save marriages anyway. You'd use terms like matrimonial fault and explain the practical effect of the special procedure in often bypassing real scrutiny.
Okay, outline the problems with the old system first. Then you'd move to the attempts at reform, focusing particularly on the Family Law Act 1996. You'd need to explain its laudable principles, but then detail the proposed process over time model with its mandatory information meetings and that long period of reflection and consideration.
And crucially, you'd need to explain why it failed so spectacularly. The unsuccessful piloting of the information meetings is the absolute key here. You'd need to detail the research findings about their ineffectiveness in actually saving marriages, their inflexibility, the potential to push uncertain people towards divorce, and how they failed to secure the necessary willing involvement of both parties. You'd link this practical failure back to the Act's inability to meet its own guiding principles, particularly the aim of minimum distress.
Right, explain the failure of the 1996 Act, and then you'd bring the story right up to the present day with the successful reform, the Divorce, Dissolution, and Separation Act 2020. You'd absolutely have to mention the catalyst, the case of Owens v. Owens, explaining how it starkly showed the flaws of the old law's behavior test in trapping someone in a broken marriage.
Yes. Explaining how Owens v. Owens demonstrated that a clearly broken marriage could be legally unsalvageable under the old system simply because the parties couldn't satisfy the court on one of the five facts. Then you detail the new system introduced by the DDSA 2020, the statement of irretrievable breakdown being taken as conclusive evidence, the complete removal of the requirement to prove the five facts, and the new simplified timeline involving the 20-week and 6-week minimum waiting periods. And remember, the one-year bar still applies.
And finally, to really answer the question, you need to address that core idea of state involvement. Does this new, almost purely procedural no-fault system, where the state essentially just accepts the applicant's statement, represent a suitable 21st century view? You could argue how it clearly reduces conflict and aligns with the Law Commission's goal of minimum bitterness, distress, and humiliation. But perhaps you can also critically consider that tension we discussed. What does it mean for the court to must accept the statement as conclusive evidence, even if the practical reality of the breakdown isn't verified by the state anymore? Does it go too far, or is it just right?
Exactly. That framework, hitting those key historical points, specific acts, the core concepts like the five facts versus the statement as conclusive evidence, the key cases like Owens v. Owens and Cleary v. Cleary, the reasons for the failure of the FLA 1996, and detailing the mechanics and rationale of the current DDSA 2020 gives you a very strong basis for discussing that essay question thoroughly.
Okay, let's quickly consider the problem question example provided in the sources as well to see the new law in action. James and Kendra, married for just 3 months. James wants a divorce because he says he's met someone else, Olivia. Kendra refuses the divorce, and they're still living together in all ways. How does the new law apply to James's situation?
Right, applying the DDSA 2020 here. First things first, the one-year bar. Remember, Section 3 of the MCA 1973 still applies. The law, even under the new system, prevents a divorce application within the first year of marriage. James and Kendra have only been married 3 months, so James simply cannot file an application yet. He absolutely must wait until after their first anniversary.
So the initial waiting period from the date of marriage still applies, even with no fault. That's the first hurdle.
Correct. Now, let's assume James waits the full year and then decides he still wants to proceed after the anniversary. Can he apply for a divorce if Kendra still refuses and, hypothetically, they are still living together in all ways?
Under the old law, this would have been incredibly difficult, wouldn't it? He'd probably have had to try and prove her behavior or his own adultery, which he couldn't rely on anyway, or wait 5 long years if she didn't consent to 2 years separation.
Exactly. A real mess, potentially. But under the new law, the DDSA 2020, James can apply for divorce as a sole applicant. Kendra's agreement, or lack thereof, is completely irrelevant to his ability to initiate the process.
Okay, so her refusal doesn't stop him from applying after the year is up. What about the ground and the truth, especially if they're still living together?
The ground is irretrievable breakdown. His application must include his statement that the marriage has broken down irretrievably. And this is the critical part under the new law. The court must take his statement as conclusive evidence of the breakdown. Section 1.3 is clear.
So even though they are, in this scenario, still living together in all ways, his statement alone is legally accepted as definitive proof that the marriage is over. The court doesn't look behind the statement.
Yes, that's the practical effect of the conclusive evidence provision. It highlights that tension we discussed. The law mandates acceptance of the statement as proof of breakdown, effectively overriding what might appear to be contrary evidence from the living situation. The court's role isn't to verify the statement's factual accuracy in that sense. It accepts it as conclusive as a matter of law.
That's a very practical example of how the new law simplifies the process dramatically and removes potential barriers and arguments compared to the old system. Okay, quick variation. What if James was in a civil partnership with, say, Lee when he met Olivia? Would the answer be different under the new law regarding dissolution?
Under the new law, since April 2022, the analysis would be essentially the same for dissolution. If James was in a civil partnership with Lee and wanted to end it after 3 months, the 1-year bar for dissolution under Section 41 of the CPA 2004 still applies. He would have to wait until after the first anniversary of their civil partnership before applying for a dissolution order.
Okay, 1-year bar applies to dissolution too. And could he apply alone if Lee refused?
Yes. Just like with divorce applications under the amended MCA 1973, an application for dissolution under the amended CPA 2004 can be made by a sole applicant. Lee's agreement is not required. The application must contain James's statement that the civil partnership has broken down irretrievably, and the court must take this statement as conclusive evidence.
And the historical difference where adultery wasn't a specific fact for dissolution under the old law, that's completely irrelevant now for the process?
Correct. Since the DDSA 2020 removed the requirement to prove any specific facts for dissolution as well as divorce, that specific historical difference in the old list of facts is no longer a factor in the process itself. The process and requirements for ending a civil partnership are now largely harmonized with those for ending a marriage under the new no-fault system, differing mainly in terminology, dissolution order versus divorce order.
That makes the application of the new law much clearer and more consistent. For both divorce and dissolution, the key elements now are the initial 1-year bar from the date of marriage partnership, followed by the ability for one or both parties to apply with a statement of irretrievable breakdown, which the court must accept as conclusive evidence, all within the procedural framework of the 20-week minimum period to conditional order and the further 6-week minimum period to final order.
That perfectly encapsulates the core changes brought by the DDSA 2020 and how the new process works in practice for both forms of legal union.
We have truly journeyed through centuries of legal development today. It's quite something. From needing those incredibly rare and expensive private acts of parliament, through the introduction of the fault-based judicial system with its mandatory 5 facts, and the practical reality of this special procedure, the ambitious but ultimately failed attempt at a process-based reform with the Family Law Act, 1996. The crucial catalyst of cases like Owens v. Owens, which so starkly highlighted the flaws in the old law. And finally, arriving at the streamlined, no-fault system under the Divorce, Dissolution, and Separation Act 2020, with its simple statement of irretrievable breakdown taken as conclusive evidence and those defined waiting periods. We've also seen how the law for dissolving civil partnerships has followed a parallel path and is now aligned with the new divorce system.
Understanding this rich history and the specific details we've repeatedly discussed, the concepts like divorce immensa et thorough, the crucial role and limitations of the 5 facts demonstrated in cases like Cleary v. Cleary and Owens v. Owens, the reasons behind the failure of the FLA 1996, the fundamental shift in emphasis under the DDSA 2020 from proving fault or separation to simply declaring breakdown, the new process with its 20-week and 6-week periods, and the continued relevance of the 1-year bar is absolutely vital for anyone trying to grasp how UK family law handles the ending of relationships today. You need these details.
It really is. And if you are indeed studying this topic, perhaps preparing for exams, understanding these concepts, being able to trace the historical evolution, knowing the key acts and dates 1857, 1969, 1973, the failed 1996 Act 2020, and the crucial implementation date of April 2022, and being able to apply the new law confidently, including the 1-year bar, the statement being conclusive evidence, and the 20-week and 6-week periods is what will serve you really well.
You've definitely got this. Review the distinctions between the old 5 facts, understand exactly why the behavior test was so problematic, think Owens v. Owens, grasp the aims versus the reality of the FLA in 1996 failure, remember the information meetings, and appreciate the fundamental change introduced by accepting the simple statement of breakdown as conclusive evidence in the new law.
We sincerely wish you the very best of luck for all your exams if you are facing them on this topic.
Thank you for joining us for this deep dive into UK divorce and dissolution law.
And here's a final thought for you to perhaps ponder. The move to a pure no-fault system under the DDSA 2020 undoubtedly aims to reduce the conflict and bitterness inherent in the old fault-based system, aligning with international trends and those long-held Law Commission objectives of minimum bitterness, distress, and humiliation. But does removing the requirement to prove any specific behavior or period of separation by taking a party's statement as conclusive evidence risk making divorce too easy, as some critics feared? Or does it simply represent a necessary legal recognition that once one or both parties subjectively experience a marriage as broken beyond repair, the law's primary role should be simply to provide a dignified and less painful process for its formal ending, respecting their autonomy? It raises an important ongoing question, I think, about the balance between the state's role in regulating marriage and respecting individual decisions about ending relationships.
Indeed, a question that the long evolution of this law, from those 18th century private acts right up to 21st century no fault, continues to highlight and probably always will.
Thanks for diving deep with us today.